It is true, of course, that that section places the obligation on the IEBC to cause the said register to be opened for inspection by members of the public at all times. In the same breath, and it is also true, that the burden of ensuring proper registration once a person has applied for registration cannot be shifted on to the elector. What is disturbing, however, was the attitude taken by Ms. Kilonzo, although she well knew that questions had been raised concerning her registration and the issue was live before she proceeded for nomination. In her own words in examination in chief and during the proceedings before the committee, she said, "I did not bother to check the register if indeed I had been registered." And in cross-examination, she is recorded as having said, "I am a trained lawyer and a diligent one. It is true that I did not check in the register to confirm my name had been entered in the Green Book." It would naturally be expected that a diligent and knowledgeable lawyer seeking to ensure from her best efforts a credible, free and fair electoral process and intent on ensuring her constitutional rights are truly safeguarded and desirous of safeguarding the Constitution would have at least bothered to check on her registration status. We found that the IEBC properly conducted itself in respect of the complaint or dispute on nominations. We are unable to agree with her that her legitimate expectation to be a candidate was contravened by way of breach of her political rights under Article 38 or of her right to fair administrative action under Article 47. Ultimately, therefore, the Wiper Party's legitimate expectation remains inviolable except as it may otherwise be affected under law. This leads us naturally to the next limb of this issue, and that is whether Wiper Party has a legitimate expectation to field an alternative candidate. We have carefully perused the evidence on record. We find that there is no evidence before the committee, and there is none before us, that Wiper Party knew that Ms. Kilonzo was not a registered voter. We do not know how Section 72(2) of the Act can be invoked as urged by Mr. Kigodo for the fourth interested party. The Constitution is about opening space for citizens so that they can liberally express themselves within its confines. Consequently, it is our finding that limiting the Wiper Party's political rights would be inimical to the exercise of democratic rights and freedoms of its members. We would go further and add that Article 1(2) of the Constitution clearly provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. In our view, so long as the political party has not contravened any law, there is no reason to deny it the opportunity of fielding a candidate in any election. We note that Wiper Party may not have been vigilant and diligent enough when it came to the fielding of Ms. Kilonzo, but we find that the order that addresses itself to the circumstances and requirements of our society is to allow Wiper Party to exercise its right to nominate another candidate for Makueni's county Senate seat.